May 25th, plaintiff filed a motion for summary judgment on the basis of deemed omissions against defendant Salahu. Back in January of 2022, on January 21st, plaintiff served discovery requests on defendant Salahu. On the original 30-day deadline, defendant asked for a 30-day extension, which plaintiff granted, and defendant confirmed that the new deadline was now going to be March 24th, 2022. No responses were given on that date, and actually to this date, no responses have been given on the discovery request. And so plaintiff filed a motion for summary judgment on the basis of deemed omissions based on the omissions that were deemed on March 25th, that there are no genuine issues as a matter of for material fact.
All right, response.
Yes, Your Honor. In our response, which we timely filed, we had noted that we had not served plaintiff with the admissions. We will admit that we are having a hard time getting that from our client. He is just difficult to deal with. We did get those admissions given to us on Friday. I spoke to the attorney who's the lead attorney on this case, Mr. Vincent. He said he will have those admissions served to plaintiff by the end of the day, as well as a motion to undeem those admissions. In the meantime, though, we have taken depositions of both, I believe, the plaintiff and the defendant. And I guess the gist of our argument in our response is the plaintiff herself looks like she cannot identify who was the main cause of the accident. And that in itself leads to a question of material fact that needs to go to a jury. And that's not something that should be taken out of their hands. So we would ask that you deny plaintiff's motion. We will, by the end of the day, have those admissions served on plaintiff. I have Mr. Vincent's assurances. He's not here at the hearing because he's got called for a jury trial, so I'm stepping in. But we did get those on Friday, and we will have them served by the end of the day.
Response?
Well, according to Marshall v. Vice, once an admission has been admitted, whether deemed or otherwise, a party may not then introduce testimony to controvert it. So the deposition testimony cannot be brought in to controvert the admissions that were already deemed prior to the deposition testimony. And some of the admissions that were deemed was that defendant Salahu was negligent in causing the accident and that he accepted responsibility for causing the accident.
I mean, I think the appropriate way to handle this would be to grant the summary judgment. If you want to file a motion to undeem the admissions and reconsider the summary judgment, you can. But I think I don't really have any choice but to do it that way at this point. So I'm going to go ahead. Did you submit an order for me, Ms. Reilly?
Yes, Your Honor, I did.
Let me take a look. I see it. Okay. All righty. Anything else today?
No, Your Honor.
And just encourage you to, Giotto, if you guys want to fight this, that you need to follow the correct procedures. So, and you guys have a great rest of your day.
Thank you, Your Honor.
Thank you, guys. There's a Mr. Stendara here. What are you here for, sir?
Hi, Your Honor. I'm stepping in for Mr. Dennis Rosine on a motion for default judgment. I can give you the case number.
Are you set for hearing or what are you doing? I'm not sure what you're here for.
Yes, on Friday, Lisa Garrett spoke with your with your clerk and said that we had a hearing set for this morning.
Was it on the
But
DWAP docket or what? Ron,
it
did you
was
know?
not on the DWAP docket. And I did check the court's docket this morning. It doesn't really seem like it's, at least that it's not on the docket. It just indicated that you requested a hearing on it.
Give me the cause number again.
Cause number is DC 22-08053.
DC 22-08053. Okay, let me take a look at it.
Yes, that's Louise Smith Taylor versus Catherine Michelle Burns.
Okay. Oh, yeah. Okay. So there was a lot missing from his default, unfortunately. There's no certificate of last known address, no service member affidavit. I don't know that we need proof of damages because I think you're just trying to get a default as to the property, but we still need a certificate of last known address and a service member's affidavit. So that wasn't submitted. So we just wanted to kind of let you know that. And Rhonda, just note that on the file that we let them know that.
And it's been reset to November 7th at 9 o'clock. You are on the DWAP docket for that day.
You said November 7th, Ms.
Yes, sir.
Benson?
At 9 o'clock.
Did you get that, Mr. Sandar, though, the certificate, at least the certificate of last known address and as well as the service members affidavit? So
Yes, of course, Your Honor.
So,
And I just maybe you could provide maybe some guidance on it, because I noticed this on probably last night. We have only been able to locate Miss Burns' month and year of birth. We're actually surprised we were able to serve her in the first place. And I know to conduct the proper service member search, you do need her date of birth as well. We've uncovered a lot of information about her previous felony convictions that likely disqualify her from military service in the first place.
this happens all the time in car accident cases. They almost never have that information. And so just run what you've got and they'll probably come back with something inconclusive, but at least include it so we know.
Okay, perfect. Well, thank you, Your Honor.
All right. Thank you. You have a great rest of your day.
You too.